Good afternoon, everyone, and welcome to the Licensing Act panel. The first order of business is to elect a chair. So
I'd like to propose Councillor Ali Gordon-Creed. Seconded.
Okay, great. Thank you. Welcome. Good afternoon. I'm Ali Gordon-Creed, this year held. I'm chair of the panel. Councillors Catherine Keats-Rowan and Anne Rees and Celia running me today on the panel. Before we proceed with the meeting, please can everyone ensure that all their mobile devices are switched off for silent so that the computers will allowing. And can I ask that, are we expecting one person online? Remotely?
No, just check. I don't think there is.
Fine. In the event of a fire, Democratic Services Officers, Candida will show us out, and there's a couple of exits which she will indicate. If that does happen, the meeting will resume once all the attendees have returned to the meeting room and are ready to continue. If you have a question to ask in the meeting, please raise your hand to allow me. Please do not speak unless you're invited to, and please do not interrupt others when they are speaking. Are there any other questions so far?
Could I just raise a point, please, Chair? Russell Sharma from Trading Standards. We received some further information prior to the hearing, which I made a submission to the local authority on Monday, which was the earliest possible I could do.
Yeah.
And I brought copies of that today, but I just wanted to get a legal advice whether that additional information can be submitted in accordance with Regulation 18 of the hearings regulations.
I refer to legal on that.
I think we really need to have the agreement. Has that been shared with the other side?
If I can clarify, so the notice of hearings had said that the deadline for any additional material that we could circulate in advance of the hearing was on Friday last week. So obviously that material wasn't provided by that deadline, so I said I couldn't circulate it in advance of the hearing, but with the agreement of all parties, material can be circulated at the hearing itself. So essentially it's all parties, whether the licence holder and Mr. French is the other party to the hearing, agree that that material can be circulated.
I sent it to all parties by email on Monday.
Oh, okay.
Did that include the licence holder?
Yes.
That I hadn't appreciated you actually already sent it. Do you have any representations on it?
No, I don't. We've seen it.
Right.
So I'm not going to say it can't be circulated.
Thank you. Obviously, our members haven't had.
And I have 50 copies for everybody, if that's okay, and I'll deal with that in my later submission. Just wanted to clarify this at that point in this stage.
No, that's clear.
And I imagine you're going to speak to them as well. When you do speak.
Yes, I will.
Yeah.
Just for completeness, I have no objections to that being circulated.
I've just retained one for myself, if that's okay.
Right. Yes. Yes. So thank you for when you take it out to the agenda.
The procedure.
Declarations of interest.
Yes,
and things like that.
yeah.
Do any of members of the panel have any declarations of interest? None. The procedure for this meeting was included in the agenda pack. Could I ask if everyone has understood the procedure, or does anyone have any questions they wish to ask?
I'm afraid that didn't reach me. I have seen other hearings in this hearings before this panel. So if it works as it normally does, I suspect I don't have any questions.
You have got a copy of the agenda pack.
I don't.
Right.
If I can raise a clarification. So when I sent the notice of hearing out, it was clarified who initially we received some additional material from the licence holder solicitor, and I asked whether he would want to be the point of contact, and I had no reply. So the point of contact was left as the licence holder, so he was emailed a copy of the paperwork.
I understand that. He may well have seen it. All I can say is that I have.
I'd say it's his responsibility to send that to the
Yes, you can have a quick, it is as it's normally conducted, but send it to me.
It is, I would like it sent to me, but if it's as it's normally conducted, I don't see that needs to hold up the hearing in any way.
Thank you. So this application is for the review of a premises license under the Licensing Act 2003. Premier Store, 150 Broadway, Didcot, OX 11 8RJ. I will now begin this item and I invite the licensing officer to present their report.
Thank you, Chair. As you've outlined, the matter that we're here to discuss today is the review application that has been submitted in respect of the Premier Store at 150 Broadway in Didcot. A responsible authority or other person may submit a review application because of a matter arising at a licensed premises in connection with any of the 4 licensing objectives. The application has been submitted by South Oxfordshire District Council Licensing Authority in its role as a responsible authority. Brief point of clarification on that. Because the licensing authority is a responsible authority, in circumstances like this, the licensing authority wears 2 hats. So I'm here as the administrator of the application. My colleague, Mr. French, is here as the responsible authority. The grounds for the review are provided in detail within the application from page 23 of your papers. In summary, the points raised by the licensing authority are that smuggled tobacco, illegal e-cigarettes, non-compliance with licence conditions and licensing law, and the general lack of engagement from the licence holder have led to the licensing objectives being undermined. During the consultation period for the application, 1 representation has been received from the Trading Standards Responsible Authority. You can find their submissions from page 66 of your papers. A timeline of events is provided within their submission, which summarises their concerns. In short, being the supply of illegal tobacco and e-cigarettes, out-of-date food and incorrectly labelled food products, and unauthorised food additives, as well as non-compliance with legal requirements. During the consultation period, written submissions were also provided on behalf of the licence holder. You can find these submissions from page 55 of your papers, and they also provided a supporting bundle of documentation and evidence which is attached from page 99. These submissions detail the premise licence holder's responses to the concerns that are raised within the review application and what steps they have since taken. To assist you in your decision making today, your papers include case law and guidance. So you can find relevant sections of the Council's policy at section 4.1 of your papers on page 11. Relevant sections of the Secretary of State's guidance at section 4.2 on page 13. Relevant case law examples are given at section 4.3 on page 16. In making your decision today, you must have regard to the information that's within your papers and is presented to you today by those party to the hearing, the guidance issued by the Secretary of State, the Council's licensing policy, and the steps that are appropriate to promote the licensing objectives. The options available to you, as mentioned at section 55 of the Licensing Act, are that you can modify the conditions of the licence by adding, omitting, or rewording any condition, to exclude a licensable activity from the scope of the licence, to remove the designated premises supervisor, to suspend the licence for a period of not exceeding 3 months, or to revoke the licence. These options, as well as the financial and legal implications, are mentioned at sections 5, 6, and 7 of your papers. That is a brief summary of the reasons that we're here today, but please let me know if I can clarify anything or provide any answers to questions.
I'm sending you an email now, because I found your email online. so we can send it papers. I'm confident that I will have seen everything that's in. I would just like to make sure that I'm working exactly the same as everyone else. I do apologise for me today.
So over to the chair. I think at this point.
Thank you for presenting the report. I now invite panel members to ask any questions they may have to the licensing officer. No. Right, thank you. Does the license holder have any questions for the applicant?
No, thank you.
Is the licensing?
I just, yeah, I mean,
Actually, yeah.
so, yeah, the applicant, because this is a review,
Yeah.
it's, yeah, the applicant is Mr. French.
So can I just check with Mr. French?
I don't have any questions for Mr. Fletcher.
Okay,
Thank you.
and does the licensing officer have?
No.
If any attending party wishes to speak, please raise your hand now. I will proceed through each speaker who has indicated they wish to make a verbal statement.
We're now actually, yes, we've now actually got the,
Yes.
Okay. So if everyone's content and no one's got questions for the licensing officer, we'll move on to the applicant's case.
Shall I go? Obviously. Thank you very much and good afternoon to everyone. The licensing authority, wearing its hat as a responsible authority, has submitted this application for the review of a premises license for Premier Store 150 Broadway in Didcot. As Mr. Fletcher has outlined, the responsible authority is a body such as ourselves, the police, trading standards, who are specifically named in the Act, having a particular interest in ensuring that licence holders comply with the Act, relevant laws and legislation. Before I briefly summarise the reasons for the review, I think it's important to note that the licensing authority generally is required by virtue of paragraph 4 of the Licensing Act 2003 to carry out its functions with a view to promoting the 4 licensing objectives. Licence holders are also required to promote the 4 licensing objectives. The panel will be aware that the licensing is a regulatory process that is not dependent or reliant on a licence holder or applicant accruing convictions. It is not a criminal proceeding. Indeed, the Secretary of State's guidance, which the Council must have regard to, at paragraph 11.25, succinctly states the following: that reviews are part of the regulatory process introduced by the 2003 Act and are not part of criminal law or procedure. It goes on to say at paragraph 11.26 of the same guidance that where the licensing authority is conducting a review on the grounds that the premises being used for criminal purposes, its role is solely to determine what steps should be taken in connection to the premises license for the promotion of the 4 licensing objectives. And lastly, as it's noted within the Licensing Act itself, in paragraph 51, the Licensing Act states that it is a review of a premises license, not a review of a premises license holder. So, for example, in taxi licensing, we are looking at whether a taxi driver is fit and proper. That is not the case here. We're strictly looking at a review of the license that is in force at this premises. Each premises license issued states a premises license holder and a designated premises supervisor, or the DPS, as I'm going to shorten that down for the rest of the hearing. The DPS is usually the person we'd expect to find in day-to-day control of the premises, so there is no requirement for them to continually be there. Obviously, the premises license holder is the person responsible for that license. In this instance, Sackshar Limited, which Mr. Desai is the premises license holder, person of significant control over the business and the DPS of this premises. So, why are we here today? I think the review can be summarised as concerning 5 different areas. That is the sale or storage of smuggled tobacco on the licensed premises, the sale of illegal vapes or e-cigarettes, to give them their proper term, the licence condition breaches identified over 3 separate licensing inspections carried out by the licensing authority, the failure of the licence holder / DPS to engage in these matters, and the ongoing issues around food safety, food labelling, and the most recent discovery of tobacco blunts at the premises as recently as the 21st of March 2025, which was, I think, 3 weeks ago. So I'm going to start by briefly touching on the smuggled tobacco and the illegal e-cigarettes, although I'm not going to spend too much time on this as Mr. Sharland has greater expertise on that matter than I do. The panel will be aware from reading the review application and the sections of the Secretary of State's guidance contained in the report that there are a handful of specific criminal offences listed in the Secretary of State's guidance at paragraph 11.27, which should be treated as particularly serious. One of those is the sale or storage of smuggled tobacco on a licensed premises. Please note there is no reference in that section to a quantity, a minimum quantity that must be found to be regarded as particularly serious. It is simply the sale or storage of smuggled tobacco on a licensed premises. In the context of this review application, this is relevant to the visit carried out by our trading standards colleagues on the 29th of May 2024 to the premises where a quantity of such products were detected and seized. The panel will further note at the Secretary of State's guidance 11.28 that the revocation of the premises licence, even in the first instance of such an offence taking place, should be seriously considered. Why is this serious? Why is this particular offence considered to be so serious? Again, Mr. Sharland has greater expertise on this than I, but smuggled tobacco products can often be legitimate products which have been imported, distributed and sold whilst evading duty, or can be incorrectly labelled and non-compliant with UK law. In most instances, those types of products are sold at reduced rates, which undercuts legitimate retailers. Presumably, given all of this, is why the government has sought to include such an offence in the list stated at paragraph 11.27 of the guidance. I would also note that whilst such matters are usually dealt with by trading standards under their various legislation, that the sale or storage of smuggled products on a licensed premises is also a specific offence in the Licensing Act itself, at paragraph 144, and has been since 2005. Again, no minimum quantity is specified in the guidance or the Licensing Act, or grace given for it being an alleged isolated incident, as claimed in the submissions made on behalf of the licence holder on page 57. The fact is, non-duty paid tobacco products were located on the premises. As I mentioned in my introduction, my comments today, the licensing authority is only concerned with the promotion of the licensing objectives and not criminal sanctions. However, it should be noted that the licence holder was issued a fixed penalty notice of £2,500 by HMRC for these products being on the premises. That was after HMRC had considered representations put forward by the licence holder. For completeness, that letter from HMRC issuing that fixed penalty notice and the reasons why is in your papers on page 124. I do not believe there is any dispute amongst the parties here today that smuggled tobacco was found on the premises when it shouldn't have been there. In regards to e-cigarettes, or more colloquially vapes, a large quantity of illegal high-capacity vapes were also seized from the premises on the visit carried out by trading standards on the 29th of May 2024. Again, the issues around vaping, I shall leave for Mr. Sharland to explain to you in more detail. My understanding is that as we sit here today, those high-capacity vapes remain illegal and should not have been in the premises. But I will stand to be corrected by Mr. Sharland if that's not correct. Moving on to the licensing inspections. So why does the licensing authority conduct licensing inspections? It's to ensure that that license holders are promoting the 4 licensing objectives. B, it is to ensure that the license holders are complying with the law. And C is to ensure that license holders are complying with conditions which, if they don't, are criminal offences and have been placed on the licence to promote the 4 licensing objectives. The licensing authority is the regulatory body that administers and enforces the Licensing Act, carry out these inspections to ensure that these matters are being complied with and that public safety is not put at risk. The inspection letters can be found in your papers starting at page 37 through to page 45. They outline all of the licence condition breaches from the 3 visits, and ask the licence holder at the end of each letter to contact the licensing authority when the issues have been resolved. To date, no correspondence has ever been received directly from the licence holder in respect of the issues raised in those letters. The panel will note that the licence condition breaches are numerous and repetitive over the course of 3 visits. Each licence condition breach or breach of the law is a criminal offence. The Licensing Act states that under section 136, the Licensing Act itself, carrying on unauthorised licence or activities, which a premises would do if the conditions are not being complied with, has a penalty of 6 months in prison and an unlimited fine. So these aren't sort of trivial issues. These are serious matters that any licence holder should be complying with. I'd like to point out to the panel that submission put forward on behalf of the licence holder at the top of page 65 in your papers, namely that Mr. Desai's licensing consultant at the time failed to keep Mr. Desai informed as to the various inspections of the premises, is not correct. Every single inspection letter was triple handled by this council, posted to the licence holder's address, emailed to Mr. Desai directly, and posted to the premises, which I'm sure we would all agree that is going above and beyond what the council should be doing. I'd also point out that the first inspection letter of the 3rd of July was even handed to Mr. Desai at a performance meeting on the 9th of July. Therefore, Mr. Desai was fully aware of the issues early on and could have at any point contacted the licensing authority about them. In the same submission submitted on behalf of the licence holder at the top of page 65, it is only now that apparently Mr. Desai has decided to, quote, step in, unquote, to take matters in hand. This is a rather curious statement given that the licence and the conditions attached to it have been in place since 2021. Why Mr. Desai has chosen this moment to step in and, quote, spearhead the improvements of the premises that he has been the premise licence holder and DPS of since 2021, perhaps we'll find out today. However, now that we do have submissions on behalf of the licence holder, there seems to be, at least in my reading, an attempt to minimise and disregard the finding of the 3 licensing inspections. As I mentioned just a moment ago, each breach, including breach of condition, is a criminal offence pursuant to section 136 of the Licensing Act, and the penalty for each offence is 6 months in prison and an unlimited fine. I'd also point out again that conditions 1 to 7 attached to the current licence have been in place since 2021 and were even agreed with Mr. Desai in 2021, and that email agreeing to those conditions is in your review paperwork. He agreed them at the time and would have been thoroughly aware of what they are and the requirement to comply with them. The conditions that were found not being complied with over the course of 3 inspections are what I would consider basic things, basic stuff that one would assume that a premises selling age-restricted products should be complying with as a matter of course. Ensuring that the CCTV works. To date, we have no evidence it records for the 30 days as required by the licence condition, yet it is stated on page 61 of the applicant's submissions that it is now suddenly compliant. The implementation of a challenge 25 age verification policy, again, a condition since 2021. Again, the licence holder's submission at paragraph 21 on page 62 states that this was rectified after the first inspection, which is clearly missing the point as it should have been in place since 2021. Written staff and refresher training seems to have been the condition that the premises seems to have struggled with the most. At no point during any of the 3 inspections was any written training produced or provided to this council, either at the inspections or subsequently. At paragraph 23 on page 62 of the applicant's submissions, it states training had been provided verbally. The condition clearly states that training should be in written format and refreshed every 6 months. Therefore, verbal training is irrelevant and insufficient to comply with the condition. It should be noted that the training records produced at page 135 onwards, which were allegedly completed at the end of December 2024, do not comply with the wording of the licensing condition. So as far as I'm concerned, that remains a breach of licensing condition. The use of a refusal register, again, basic stuff, particularly when you're selling age-restricted products. The condition is quite clear on what is required in respect of this and has remained unchanged since 2021. The submission on behalf of the applicant at paragraph 28 at the top of page 63 states the system did not go far enough and questions why this matter is mentioned within the review paperwork. So fairly simple, really, why it's mentioned in the review paperwork, because it demonstrates a lack of compliance with licence conditions which have been in place since 2021. The fact that it took officers to explain this to a licence holder is a concern. In relation to having signage at the door asking customers to leave quietly, also a licence condition since 2021. This has never been complied with over 3 inspections. Again, not a particularly difficult thing to comply with, I would submit. The submissions on behalf of the licence holder seem to dismiss this as a lack of compliance is of less significance in the context of the application as a whole. I'm not clear what that statement means, but a breach of a licence condition is a criminal offence and it would be treated in exactly the same way as any other breach of licence condition. There are other licence conditions I've not touched on. Even the relatively new condition of keeping invoices of all tobacco products on site was found in breach during the inspection of 19th of December. The premises licence holder seems unable or unwilling to comply with conditions that he agreed to, has taken no demonstrable steps to engage with the process undertaken by the licensing authority and other responsible authorities. Whilst we're on the subject of the licensing inspections, I'd also just like to briefly deal with the applicant's submission around the failure to produce a fire risk assessment, which is on page 64 of your papers at paragraphs 34 to 37. The applicant's submissions at paragraph 34 states that a visit by the fire service was arranged on the 6th of March 2025. That is a week after the review application was submitted and is not even scheduled to take place until the 6th of May 2025. Noted that this took place after the submission of this review application, it is curious why it has not taken place before. The applicant's submission goes on to say at paragraph 35 that a fire risk assessment is in the process of being finalised. This would indicate to me that one has not existed to this point. The panel will be aware that individual business owners have been, since 2005, been required under the Regulatory Reform Fire Safety Order to have a fire risk assessment in place. And again, this should have been in place in 2021 when Mr. Desai opened the premises, not over 4 years later when it was brought to his attention via multiple licensing inspections. The fact that the licence holder had not complied with the requirement clearly undermines the promotion of the licensing objectives and puts both Mr. Desai's staff and customers at risk. Within the licence holder's submission at paragraph 36 on page 64, it makes a statement that the licensing regime is not designed to duplicate existing legislation. That is agreed. It goes on at paragraph 37 that it has minimal impact on the promotion of the licensing objectives. That is not agreed. The Secretary of State's guidance to the Licensing Act at paragraph 1.19 states that licence holders should be mindful of the requirements and responsibilities placed upon them by other legislation. One of those pieces of legislation is the Regulatory Reform Order. Compliance with it is not optional and shows further legislative breaches at the premises. Paragraph 2.9 of the same guidance specifically says that a number of matters should be considered in relation to the public safety licensing objectives, and one of those is fire safety. It clearly undermines the promotion of the licensing objectives and puts public, staff, and even the licence holder himself at risk for failing to comply with fire safety legislation. Lastly, on the submissions from the applicant, the photos at pages 158 to 171 are the same photos which were sent to me on the 10th of October 2024 by Mr. Desai's former licensing consultant. By that person's own admission at the time, full compliance had not been reached. The photos also contain the same photo of the fire extinguisher propping open the door on page 166, a checklist provided completed stating that a number of things have been completed when they had not on page 169. For example, the checklist states that written training records have been completed at the time of this submission on the 10th of October, which was not correct given the applicant's submissions for this review hearing states that training records were completed on the 27th of December, some 2.5 months later. There are also ticks for the CCTV functioning and for it recording 31 days, but again, that is not as the submissions from the licence holder for this review indicate is correct. Therefore, it is a concern that these photos have been recycled and reproduced without explanation and which also contain details within them that are not true. The panel will note on page 27 and 28 of your papers details of all of the correspondence sent to Mr. Desai and the licensing consultant who was representing him at the time. At any time, Mr. Desai could have, quote, stepped in, unquote, to deal with the matters at his own premises. Even when the issues from the first inspections were explained to him in person and a copy of the first inspection letter handed to him, during the performance meeting of 9th of July 2024, no follow-up was ever received from him. No contact was made despite timescales being given to inform the council that these matters had been rectified. The chronology on pages 27 and 28 are just a summary of the correspondence sent by the licensing authority. I'm sure Mr. Sharland and our trading standards colleagues may have many, many more examples of correspondence not responded to. Perhaps we might hear from Mr. Desai today why he didn't ever feel the need to quote step in, unquote, at any time before today's hearing, given he is the premises license holder, sole director of the company, not sole director, but a joint director of the company with significant interest and designated premises supervisor. Lastly, I'll ask my colleagues from Trading Standards to outline the ongoing concerns around the finding of food being sold past its use by dairy, issues with food labelling, issues with products being sold with banned additives in them, etc. The panel will recognise that selling such products is illegal and undermines the promotion of the licensing objectives. And as I stated earlier, these issues were identified as recently as 3 weeks ago, on the 21st of March. So this is not ancient history. Why such products are being sold or displayed on the premises, I do not know. Perhaps we might find out today. However, it is another example of the licence holder being in breach of yet another set of regulatory and legislative requirements under the various food safety legislation, and the regulations which undermine and continuing breach of those regulations continues to undermine the licensing objectives. I'll stop there, but I'm happy to answer any questions you may have. Thank you.
Yeah, just a couple of clarifications. Right at the beginning, you were going through the different things: tobacco, vapes, breach conditions, engagement failure, public safety, and past sell by date. Then you said something about the 21st of March. Was it tobacco?
Blunts.
Plants.
Blunts.
Blunts. Oh, okay.
I'm sure Mr. Sharman will be able to tell
Is that
you.
plants? What?
No, not plants, unfortunately, no.
Okay, and then the other question I had was on checking of fire equipment, and on page 63, it mentions equipment was being checked, although it's accepted that documentation to that effect was not available. So how do you know it was being checked? Do you just...
Well, that's the point. So there's 2 issues of the fire equipment. There's a condition, which is number 7,
Yeah.
says that the premise license holder, or I don't have it in front of me, the premise license holder must check, basically document that they are checking the fire equipment in store, which there's no documentary evidence of that was ever done. And as we've seen from the photos, I think the fire equipment was just propping open doors. And there's a separate issue with the fire risk assessment, which is generally what the fire service would ask to see, which individual business holders, business owners, and even people who run this building should have in place to make sure that escape routes and capacity and things like that are taken into account.
Thank you.
No further questions? Thank you very much, Richard. We move on to...
I think
Questions from the licence holder.
Mr. French, are you aware that Trading Standards conducted an investigation at the premises on the 10th of April, so last week? No. All right, thank you. But those are the only questions that I have. Thank you for your choice.
So, does the licensing officer have any questions?
No.
Anyone else want to make any?
It's now trading standards. Who will, I believe, present.
You might just want to introduce yourself
Yeah.
before you speak.
Certainly.
Thank you.
Good afternoon, Chair. Good afternoon, panel. I'm Russell Sharland, Tobacco Control Officer, and representing Oxford County Council, excuse me, Trading Standards today. Trading Standards have joined this review of the premises licence for the reasons outlined on in our submission. I thank you for reading those in advance. And if I could ask you to just have pages 66 and 67 open while I go through these. As you'll appreciate, there is a degree of overlap between what the licensing officer has already spoken to you about and what the trading standards submissions are. I will try not to be too repetitive, but I will try and talk you through some of these points and amplify those. So First off, I'd like to start off with what you've read in the review application about the seizure of the illegal cigarettes and the electronic cigarettes or vapes. If those products are in possession for supply, that constitutes alleged criminal offences, as you've heard. But however, and this is an important point, this review isn't about determining the guilt or innocence of any individual. It's to ensure the promotion of the licensing objectives. And in this regard, your task has been simplified. Do you find that licensing objectives have been breached? As you can see on the timeline of events on page 66, Trading Standards received a complaint last year alleging 2 sales of illegal electronic cigarettes. And the complainant said that they were stored on a tray under the till. Trading Standards Officer Simon Mitchell, who is with me today and can answer any questions that you may have, is the authority's lead officer on underage sales and illegal vapes. He visited the premises as a result of the complaint and identified and seized 66 illegal vapes from under the counter. But he also discovered 366 cigarettes, which were also stored under the counter. If I can ask you to turn to Annex 1, which is on page 70 to 72 of your pack, you can see pictures of the vape products. Now, just for the avoidance of any doubt, the products were seized because they were illegal at that time. They remain illegal now, and they will continue to be illegal from the 1st of June when the single-use disposable vape ban comes into force. If I can ask you to also look at page 73, this shows where the illegal cigarettes were stored alongside an illegal vape pictured. Now, these cigarettes consisted of 2 opened multi-packs, both containing 180 cigarettes in each. What that means is both packets had 1 unit pack, not there. As has been the case with the vast majority of first-time seizures of illegal vapes, Officer Mitchell sent a detailed letter of advice and proposed that the matter be dealt with by way of voluntary forfeiture and compliance with various conditions, and that's laid out in an advice letter in Annex 3. The illegal cigarettes were passed to me as the Tobacco Control Officer, and I wrote to Sapshire Limited informing the company that Trading Standards was considering whether it was appropriate to institute a review of the premises licence. Now, the reason for that is, as Officer French has outlined, illegal cigarettes stored on a licensed premises is treated particularly seriously by the guidance, and so Trading Standards rightly considered whether it was appropriate at that time to institute a review. And to help us in that decision, we requested a meeting with Mr. Desai, his licensing consultant, Mr. Singh, and licensing officer French. The electronic cigarettes were voluntarily forfeited and an acknowledgement form was signed, and you can see those documents on page 87 and 88. At the meeting, Mr. Desai explained that the seized cigarettes were a gift from a regular customer to a member of staff who had kept them in the premises. Mr. Desai accepted at the meeting that it was a breach of the licensing objectives for contraband to be stored in a licensed premises. It was agreed at that meeting that if the name and the contact details of the customer were provided, Trading Standards would then make inquiries to confirm that account. It was also explained that if Trading Standards were minded to institute a review, it would request the application of certain conditions. And so a proposal was discussed and provided, and those conditions given. And it was agreed that if a minor variation was applied for by the premises licence holder, that might negate the need to bring a review at that time. And there's a summary of the meeting at page 89. 2 weeks on from the meeting, the customer details had not been provided, so a chaser email was sent. Eventually, a reply was received 3 weeks later, explaining that Mr. Desai had been unable to locate the customer, who may have left the area or returned to their home country. As a result, he completed a form for voluntary forfeiture, which you can see on page 92. As a result, a referral was then made by trading standards to HMRC. And I understand from the submission documents, we're not at liberty to know what HMRC decide, but we've seen from the submission from the licence holder that HMRC issued a £2,500 civil penalty to Sapshire Limited for those cigarettes, and that was paid in full. Now, Mr. Desai was informed in writing that he had the right to appeal that decision to an independent tribunal, but he chose not to and paid that penalty. On the 19th of December, a joint trading standards and licensing visit took place at the premises, and again, Officer Mitchell attended. The tobacco and the vape products were all legally compliant, which was positive. But it was noted that the new conditions were not being complied with, as there were no invoices or receipts for the vapes, which should have been available for inspection. At that time, Officer Mitchell also identified that there were imported food and drink products with no English labelling, and products containing prohibited additives were identified. And he referred them to the Trading Standards Food and Farming team. Trading Standards Officer Joe Smith, who is also present with me today, should you have any further questions, conducted a food visit on the 24th of January and identified numerous non-compliances. There were 9 products past their use-by date, which I think members will understand speaks for itself. There are also non-compliant American imported food products. That means food products that don't comply with UK labelling requirements. And there are also, for concern, 4 food lines with unauthorised additives declared on the labelling. Now, what that means is these are additives that have been declared in the European Union and kept in the UK as not being legal to be included in our food stuff. They may be legal in other countries in the world, but not for supply in the UK. And so Officer Smith highlighted those, and they were immediately removed from sale. There was then correspondence between Officer Smith and a colleague with Mr. Desai in terms of getting invoices for these products. And as the timeline explains, there were more delays beyond the very reasonable deadlines given. As a result, a revisit took place on the 21st of March. The food labelling was still non-compliant, and so quite reasonably, Officer Smith extended the deadline to 7th of April. You heard earlier about the tobacco blunts. So tobacco blunts are a tobacco product, and all tobacco products for many years now must not be on open display. And that's so that children, it's a denormalisation strategy, that children don't see these products. And that's why the smoking rate is the lowest it has been in history, one of the contributing factors. But in this case, Officer Smith identified that tobacco blunts were on open display on shelving, which is a criminal offence. When it was pointed out, they were removed immediately from sale. One of the agreed licence conditions was that a legal tobacco poster had to be displayed at the sales area, and it was not displayed. Replacement signs were given, and I understand that they are now being displayed. A revisit has taken place last week, and Officer Smith has advised me that everything is now in compliance, apart from one of the conditions that the conditions includes nicotine-containing products, that includes nicotine pouches, and those receipts and invoices weren't present, although they were then supplied via email. And then last week, the Trading Standards Authority received a written complaint from a member of the public. That was received by the service on 4th of April, and I'll just read what the complaint said. I'm writing to make you aware that this business name, Premier Store, address 150 Broadway, Didcot, Oxon, is selling vapes and e-cigarettes to children under 18. This is illegal, harming to children, and should be stopped. I would like to request that proper actions to be taken, please, as soon as possible. This complainant was not anonymous. They supplied their details. They are a professional person, but in agreement with them, they have requested that their details they remain anonymised as part of this. I subsequently spoke to the complainant over the telephone and had a conversation, and I am of the belief that this complainant is genuine, and everything that was told to me was in no way malicious or vexatiously motivated. It was agreed that I make notes of that conversation at that time. It was agreed that I would write up those notes and email them to the complainant for that person to agree whether what I wrote was a correct summary of what they had told me. And they confirmed that on Monday morning, so that was the earliest opportunity I had to then submit it to all parties. So I'll just read out my summary, which was approved by the complainant. Had concerns that the Premier Store and Broadway Didcot were selling electronic cigarettes or vapes to underage children. This was because had twice witnessed what they believed were supplies to underage children, including when they saw a woman buying one and immediately giving it to her teenage daughter, who looked clearly under the age of 18, and no ID checks were made by staff. At the end of February or early March, they discovered their son, who was 17, with 4 vapes, and the complainant retained those vapes and sent me the photographs that are attached. And having questioned the son, he admitted that he had purchased them himself from the store. The complainant's concerned that underage children are able to purchase these products from the store and then get addicted to nicotine. They contacted Trading Standards because they wanted something done about this situation. The vapes themselves are, they were designed for adult smokers. They're a smoking cessation tool, and they've been very successful in helping bring down the smoking rate. But unfortunately, in recent years, the evidence has shown that underage children are now using these products while having never been a smoker. As a result of that, on the 1st of June, we are having a single-use disposable vape ban to try and reduce the take-up of under 18s and non-smokers. So this is why we take these issues very seriously. The seized e-cigarettes were seized because they don't comply with various things, but most importantly, they don't comply with the capacities of nicotine-containing liquid. The maximum capacity for a single disposable use vape was 2 millilitres, with some of those Officer Mitchell seized were more than 5 times. And obviously, the bigger the product, the more someone will use it, and the more likely they are to get addicted to nicotine. It is of concern that we have received complaints about underage sales for all the reasons I've outlined. And that is why when the licensing officer made the review, Trading Standards have joined it. That concludes the representation panel, unless I or any of my colleagues can assist you further.
Thank you so much, Russell. Do any of your other colleagues want to speak at this time?
Just to say that if any of you've got any questions about how the illegal vapes are illegal or breach the UK law, I'm more than happy to field those. You know, the usual thing is, as I will say, the high capacity of these products, 5 and up to 7 times the legal capacity of these ones. If I believe there were some R&M Tornado products in there, which are 14 to 18 millilitres in capacity. And then there are things like health warnings, which are undersized. And perhaps of real concern is the lack of traceability information on these products. They're all being manufactured in China. They are illegal products, so they are being smuggled into this country for sale. We have got no idea what is in them. Quality control, again, we have no idea. And if there is any products with the problems with these products, there is simply no way to recall them because there is no responsible body that we can contact to find out where they have gone. So there is a risk associated with these products. That is very real. But again, if you have any further questions about any more about it, I'm more than happy to complete those.
Yeah, I was going to pick up on that, which you just explained now. But can I just understand? So I think from what I understand from your colleague, I'm sorry, I've forgotten your name, but they were tobacco and vape compliant when they were visited in December. So this was prior, the illegal vapes were prior to that.
Yes, the illegal vapes were only found at the premises.
So these
During the
pictures,
initial
these
visit.
pictures are legal vapes, or
Yes.
yeah, that's the.
They remain age restricted, and they are
Yes.
those ones appear to be
Yes.
single use.
But I'm just trying to understand the different situations that we're looking at here. And then the other thing I was, however, when you visited in December, it fell on the food, which I think,
Yeah, I picked up.
and so in terms of I think unauthorized additives, what's the impact of that potentially on health or people? Or I mean, there's a reason that presumably why they're not authorized in this country.
Yeah, I think there's a lot of research suggests there's these additives can cause cancer, and the European Union, which made the decision before we left the EU, decided that they should not be within food within the EU, and obviously now in the UK. So that's the decision that's been made, and they're not allowed to be sold in the UK legally.
And the labelling?
Yeah, so the labelling, there's certain mandatory information that needs to be on. Again, the legislation's been taken from the EU that we've then got in the UK now. There's particular mandatory information. A lot of it's to do with allergen information. So in America, the allergen information is elsewhere on the package, whereas in the UK and EU, it has to be within the ingredient list. So if a UK or British person checks the information for allergen, they know where to look. It should be in the ingredients list. Obviously, if it's not got the correct labelling, because it's American products, they aren't to know that that information is elsewhere on the packet. Therefore, it's not compliant and it shouldn't be sold. There's a lot more information. So nutritional declaration, so the energy and fats and that kind of stuff is also different in the UK versus America. And also beginning of last year, it was implemented that you have to have a UK business name and address on all your food for traceability purposes. So if anything does happen to a consumer from the food, they know who to contact. And when that labelling is not compliant, the only name and address they have to go on is outside the EU address. In this case, mostly America, but there was other products as well.
So in both cases, traceability is an issue, whether it's talking about the e-cigarettes or the food.
I had a question for you, Russell. You said that the last time you went, there were correct receipts and invoices.
Yes, the conditions applied other than the nicotine pouch, but I think what we found, and what you might have heard as a common theme, is when the regulatory authorities raise an issue, it then gets dealt with. But what we need businesses to do is comply with the law and be proactive about that, because there aren't enough resources for us to be private consultants, because we literally regulate thousands of these businesses across Oxfordshire.
So those receipts were literally complied from a short period of time, basically, is what I infer from that.
Yes, I think in December it wasn't in compliance, and that was raised, and then it is now in compliance. So I think that's correct.
Any further questions? Yes.
With your permission, Chair, firstly, just a few for Mr. Charlotte, if that's all right. That call you had with the informant, what was the date of it?
Friday.
So the 10th of April. 11th, forgive me.
11th, yes.
11th. When you were on that call, did you speak to the son of the complainant?
I did not.
when you were on that call, did the complainant give you the date that they had seen the woman by the vapes?
It was, no, I didn't have a date. It was before the issue with the son.
Did she give you a description of the woman?
No.
Did she give you a description of the woman's daughter?
No.
Did she tell you how far away she was standing?
She was behind them at the till,
Did she tell you if she knew them?
but she didn't tell me, no.
Could she tell you their names?
No.
And then again, with your lead chair, just for Miss Smith, very, very briefly, when you attended last Thursday on the 10th of April, what was your view on the food labelling at the premises at that time?
Yeah, I was happy with the work that had been done by the staff members. So they had either so they'd asked their suppliers for the labelling. So for your purposes, you can ask your supplier for like an over label or an over sticker. So that then means that the labelling is then compliant with UK labelling. So from the outset of dealing with Primary Store, that is what I told the people in the shop, and also informed Mr. Desai via letter that that's what he needed to do. By last Thursday, they had either taken stock off the shelf that they didn't receive the labels from their supplier for, or they had put over stickers on the products in the store that they'd continued selling. So I was happy that they had complied with what I'd asked them to do at that point, and I had explained to them that to me they put a lot of work into it, and I was appreciative of that.
Just one more, if it's all right. What about food past its use-by date?
We found none.
Thank you very much. And thank you, Ms. Charlotte.
Yeah, following up actually from that. So when you say from the outset of dealing, so when did you first?
Is this to me?
Yes.
Yes, sorry. So I went on the 24th of January 2025, and that's when I found the first lot of issues with lots of different issues with the food. And then we followed up so I explained in person what they needed to do, and then we followed up with a letter on the 3rd of February, and all that information was told that Mr. Desai needed to request stickers from his suppliers. I also requested by email for invoices of where he'd got some of the food from, so that I could trace it back to the supplier and deal with it from a national point of view rather than a local point of view. And he did not supply that to me until the 25th of March.
So there was a visit. So I'm just
No, that's
trying to
right.
get my time scale right. So there was a visit on the 21st of March when you saw non-compliant food labelling.
24th of January, non-compliant food labelling. We asked it to be all compliant by the 7th of March. And then we went back on the 21st of March and there was no compliance. Although some of the other issues were then not there. So there was no food past its use-by date, and we didn't find any unapproved additives in food. It was just the labelling at that point on the 21st of March. And then we went back on Thursday, the 10th of April, and that is when the labelling was complied with.
Okay, thank you. And what happened between those dates?
So
Was this hearing then scheduled, or just wondering? I'm just trying to understand. Obviously there was a request to be compliant earlier in the year, and at 21st of March there still wasn't compliance.
Yes.
But there was compliance on the 10th of April.
Yes.
Okay.
I apologise, I don't know the date that this was scheduled, so.
Thank you.
27th of February was the date.
Any further questions? Anyone else
Yeah.
want to say?
May I ask Training Stanley a question? Thank you. Either one of you. Can the smuggled tobacco or the overcapacity vapes be bought via legitimate supply chains?
No, they can't. There is a personal allowance for cigarettes of 200 cigarettes. Clearly, this is above 200. So anybody who subsequently supplies beyond personal use would commit an offence. And similarly with vapes, as Officer Mitchell has explained, these products aren't for the UK market. They've been manufactured elsewhere. They've been brought into the country unlawfully, and then they're being distributed and sold by retail.
Okay, so we wouldn't know where the vapes are coming from and how they ended up in the shop.
No, it's Officer Mitchell will be able to give you chapter and verse. I think he's seized well over 10,000 of these from about 90 premises across the county. It is a major problem.
Yes, part of the warning letter that originally went to Mr. Desai with the explanation of the law concerning e-cigarettes and requesting that they were forfeited, also requested that details be provided about where the illegal products were sourced from. And I do not recall ever receiving that information.
Thank you.
Can I ask another question? So obviously this letter here from the 14th of April, which finds the applicants, I'm not quite sure how to describe it. A license holder is or representative is referring to. Is this the first time that you've had a complaint about the underage sale? Can you point out to me where else?
I'll refer to my colleague. Has there been any other complaints about underage sales?
Let me just check.
There was an initial complaint on the 21st of May last year, which started this process. And the details I have was that the complainant alleged that a third-party young person had purchased a 2,500 puff electronic cigarette, and the complainant themselves had been able to purchase a 6,000 puff Alpha Bar electronic cigarette. So Mitchell might be able to interrogate the system further. I think that is a adult and their child, but I'll wait for that to be confirmed.
So that was the first complaint received that triggered.
Yes.
Thank you.
Yes, can I ask a question? So remind me the date at which the refusal register was finally activated, because a long history of the refusal register not being available.
Just refer to. Sorry, it's 170 pages. I'll find the right.
Yes, that's
So it was non-compliant on the first visit, which was on the 3rd of July. Second visit. It wasn't found on the second visit. So at some point between the first visit on the 3rd of July and the second visit on the 4th of September, it's assumed that it was somebody had put it in compliance, but obviously due to the lack of any correspondence from anybody at the premises about it, the first we would have seen would be on the 4th of September when we did the second visit. So compliance would have been achieved somewhere between those two dates.
And can I check? Are we? Is the fire equipment now compliant? We know.
Yeah. We've only got the applicant's submissions. I say there's been no other contact from the premises about any of the matters raised in the letters.
And can I also check that none of the training and or evidence of training with travel has also.
The applicant has provided some photos, pages 98 to, well, I've got 98 to 171, which is quite a lot of them. But there are some training documents in there. But as I said in my submission, they were completed on the 27th of December. Again, we weren't notified that they'd been completed. And from my reading of them, they still don't comply with the licence condition.
I don't have any questions. It would only if we want to wait for that information that the officers are searching for.
Excuse me, Chair.
With your permission, can I just ask one question, following up to Mr. French about there being non-compliant with the condition? Why do you say that?
I say that because it doesn't include, and I appreciate that they might not do it, but it doesn't include reference to how they would handle deliveries of alcohol.
Thank you.
While we're waiting, I've got another question now. So just for clarification again, probably goes back to what I've heard so far, but the conditions were agreed by Mr. Desai back in 2021?
Yes, if you look at on page, scrolling. So on pages 34 and pages 34 to 35, you'll see there's an email from my colleague, Kate Fisher, to Mr. Desai's licensing consultant about the conditions. And right at the top, Mr. Desai's licensing consultant says that his client agrees with all of the conditions. So the ones around the staff training, the CCTV. And there's some slight rewording, I believe, of number 5. So yes, those conditions, and that's dated 14th of June 2021.
Yeah.
We have the answer.
Yeah.
So it's the initial, this all started back in May with an email from a named person, I won't name, saying, hello, my son has recently acquired the 2,500 pup vape. It's an ELUX sold from Premier on Broadway in Dicker. I then went to buy one and the owner has a tray under the till and I was able to buy a 6,000 pup alpha vape. That's how it started up. Then that was, of course, the officer to do the inspection and he found the illegal vapes in the position that the complainant alleged. But it doesn't explicitly say, it says my son, it doesn't explicitly say that the son is an adult or a child.
Okay.
And those vapes, in and of themselves, whether or not they get sold to a child, they are illegal.
Absolutely, yes.
Any other questions or any other statements?
Not from me.
No?
Can we just make clear that these vapes are dangerous?
I think we wouldn't say that they're inherently necessarily dangerous per se, because they don't comply with UK regulations, but there is a danger attached to them, as Officer Mitchell explained, because of the traceability issues, what is actually the ingredients of contact list, is any allergens or anything like that. There's a lack of the correct warnings in some cases, but I think the main issue is that there is a limit of 2 millilitres for a single-use disposable vape, and the one seized had 10 millilitres, so 5 times, and the R&M Tornado would have been up to 7 or 8 times. What that means is, so a single-use disposable vape, once you've finished it, you throw it away. But when it's 5 times as big, you'll see people, adults and children, doing this, is you continually draw on it. What that means is you get addicted to the nicotine more quickly. And this is the whole justification of the single-use ban, because this is exactly what has happened and why that we have a significant proportion of children who are vaping who have never smoked. These are not what these products were designed for. They were designed as a smoking cessation tool for adults. So, sorry, long-winded answer to say that they're not inherently dangerous, but there is danger attached to their use.
And that's
not to say that there haven't been instances where they have been found to be contaminated with dangerous products. Testing done by other authorities, admittedly not in relation to these specific ones found at this premises, have found contamination with heavy metals and things like that. There's also concerns with the some of them, because they are so large, the tank, the internal battery cannot drain it in one go, so they have to have a charging port. Again, then you're bringing in fire and electrical safety into these things, and again, the lack of traceability comes back to the fore in that we do not know quality control, we do not know batch issues, and all of those things add together. So, and we simply do not have the time and resources to test every batch that we seize. But what we have seen from testing that we've done about nicotine content is that the again, in other brands from other premises, is that the amount of nicotine contained in these things is inconsistent. It can be 0.6 or it can be 2.4 when the limit is 2% nicotine. It can be stronger. So that's the concern with these products is there's just simply too many variables, and that presents a risk. Will using one, kill you? No, but the risk is there for continual use.
The danger attached, they are therefore dangerous.
Yes, and as I sort of alluded to, the sheer length of time one of these will last. So I used a vape to quit smoking myself. A single legal 600 puff device would last someone puffing it heavily most of the day, if you were a very heavy user. But if you're then scaling it up to something which has 10,000 puffs in it, you could sit and just continue to use this device for days on end, should you do so. And that is, as Russell's alluded to, potentially habit form.
I've got another question. So, given that these are illegal e-cigarettes or vapes, did Mr. Desai give you an answer as to where they came from? Presumably you asked.
It was requested in that letter. I will just before I answer that, I want to check to see whether I've had
From my memory of the notes, that was never answered. Yeah.
There's a question maybe to direct to.
Yes,
yes, that's going to be my next protocol.
So yes, as has been mentioned, the forfeiture and acknowledgement forms, which were included with that letter and then provided at the meeting and signed and handed over to, which were handed over to Officer Charland and Officer French at the the review meeting they held, were completed and handed over. So the products have now been destroyed, and the acknowledgement form has been signed. But the other condition that was part of my initial warning letter, which was the provision of the supplier of those products, does not appear to have been complied with.
Thank you. When it comes to
Are we done with questions at this point? Yeah. And we now move to our license holder.
Plainly, it has taken far too long for this license holder to comply with the requirements of his license and to address the breaches that have been identified both by Mr. French, the licensing, and by Mr. Charland, the trading standards. But compliance has now been achieved. That is not simply lip service on the part of Mr. Desai in the face of the licensing panel reviewing the license that is held by his company, Shaksha Limited. That, I accept, would be an irresistible influence if nothing whatsoever had been done until this review was instigated. But a close and critical scrutiny of the papers that have been supplied not only by him, but by licensing and trading standard evidence, some, albeit not sufficient and not sufficiently quick, I have to accept on his behalf, but some progress made towards compliance over the period since that first investigation by licensing on the 3rd July last year. The breach identified 3rd July Challenge 25 and the refusal book. Those resolved by the time of the inspection in September. The Section 57 notice that needed to be displayed has been displayed since the end of September of last year. The CCTV camera that was not working, 1 of 9, so 8 functional, fixed by the time the licensing inspection in December. And whilst I accept we have simply Mr. Desai's word that it is set to record 30 days and does, he tells me it does record 30 days, it always has. And so in relation to whether the CCTV system itself is compliant with the condition, it is a question of whether he has provided the appropriate evidence to the licensing officer. And I accept and make no criticism whatsoever of Mr. French. He can only go on the evidence that he is provided by someone who holds a license. But staff training, the manner in which that is non-compliant, I take Mr. French's point. A breach of a license is a breach of a license, but plainly there are more severe breaches and less severe breaches. Otherwise, it is simply the delivery of alcohol that those notices we have to deal with. Otherwise, that condition is complied with. I accept that's a way of saying it is only breached in a small way, but equally, it is not as though the condition continues to be breached, and there has been training implemented in writing as of the 27th, as of December of last year. The tobacco invoices have been supplied. The invoices for the drinks that contained those additives identified by trading standards were supplied. Those are in your papers, and you may have through the collective sigh of relief. I'm not going to go through the bundle in minute detail. They are there. I know that you will have seen them. There is evidence of engagement with the Fire Safety Authority. There is evidence of him properly complying with the labelling of his foods. This is not a licence holder who does not care, because if he did not care, none of those things would have been done at all, and certainly nothing would have been done prior to the review being instigated. It is a case of someone who has been trying to comply and not doing it well or quickly enough, and not in the manner that licensing and trading standards rightly expected him to do. Because partial compliance, I accept in the community, is not sufficient. It needs to be compliant. That is where he is now. My predecessor, on behalf of Mr. Design, made submissions in writing about the extent of the breaches. I don't propose to repeat those, but they won't get better by me simply reading them out. I abandon what he said about those vapes being about to become legal. Trading standards are right. The tobacco regulations make it quite plain. Disposable vapes that have a capacity of more than 2 millilitres are prohibited, and all disposable vapes will become prohibited from June this year. I'm not entirely sure why that's in there, but please don't place any weight on that whatsoever, because in any event, they were there. They shouldn't have been. That I accept. Much was made of the failure to implement the refusal book, but there was no failure to record refusals at the Premier store. In fact, Mr. Desai has brought with him, if the chair and the panel are minded for it to be circulated, if everyone agrees, the refusal receipts from that till for the last 3 years, which will show the information that was recorded, which is the same as is in the refusal book. Again, you can see on the table he has brought it here. If permission is given, if everyone agrees, it can be circulated. All can look at it. I take the point entirely that Mr. French makes, that saying a breach is a minor breach is really nothing, because you're saying it is a breach, and he made very forceful submissions about breaches being an offence under section 136 of the Act that we're all concerned with. And or considering here today and being punishable with 6 months imprisonment and unlimited fine. But there, and perhaps it was in a flight of rhetoric, Mr. French might have slightly misstated it, because not all breaches of licenses get a prison sentence of 6 months. Not all get a fine that is astronomical. The wording of the legislation is clear: up to 6 months, up to a fine. There are differences in the severity of the breaches. That is recognised as a matter of law. It's also recognised in the guidance, because the guidance identifies which breaches are the most serious, which are not, what might lead to a revocation on the first offence, what might. You have those points, you have them in writing about the nature of the breaches. I won't go on. In relation to the most serious breaches with which we are concerned, and the ones that quite rightly spent the most time asking trading standards about, it is of course entirely right that that contraband should not have been present at the premises, regardless of the explanation. There was an explanation put forward by Mr. Desai. At the meeting that took place in July, he told trading standards they had come from a regular customer of the shop as a gift to one of the staff members there. He was asked to supply details, and then later the licensing representative representing him at that time, Mr. Singh, was to email trading standards saying, Mr. Desai cannot trace this customer, he believes they have left the area. But that email is on page 91 of the bundle. That is the response that there is. Whilst it is undoubtedly serious that those products were in place, there is no evidence of any repetition, and one might have thought that given the frequency and number of visits that trading standards have had to make to this premises, if there were contraband products, they would have been found. And so it is a one-off. The underage supply aspect raised, again, understandably by trading standards, is utterly disputed. Mr. Desai says that he does not even stock the vapes of the type that are in those photographs, the Lost Mary 7,000 puff and the Crystal Max that are demonstrated in those photographs. He has brought, again, 15K, he has brought with him, they can be circulated, again, with agreement and with the permission of this panel. I accept it's late, but after a bit of understanding, he received the letter on Monday. He has brought with him all of his tobacco invoices, cross-checked against the vapes that are in those photographs, and those particular models will not appear. So it is something that he utterly disputes. No doubt the panel will have in mind the risks of relying on what is essentially a third-party hearsay report. Mr. Sharland, no criticism again, hasn't spoken to the young person in question to find out what happened. It's a report that's been made to the young person in question's parent, who has then reported it on to trading standards. That is difficult for Mr. Desai to deal with, other than to say, well, I don't stock these vapes. It couldn't have happened. The date can't be given. He can't go and check the CCTV. He can't go and ask staff members, do you remember someone coming in who looked a bit young that you shouldn't have supplied? Secondly, in relation to the supply to the mother and her girl that was allegedly made, again, we have no date, we have no identifying details, no description of the girl, no indication of whether or not she was known, and nothing to indicate, in fact, that this girl was underage, other than the fact that she looked young. And it is entirely possible for people's ages to be difficult to ascertain when looking. Not a point that I need to press any further, simple matter of common sense. So, undoubtedly, issue raised with trading standards in May, serious, but a one-off, dealt with, no repetition, and the allegations that have surfaced more recently are utterly disputed, and indeed, given what's been put before the licensing panel hearing, given the denial that Mr. Desai makes, I just urge caution before attributing them too much weight. Why has compliance been so slow? That has been dealt with in the skeleton. Mr. Desai engaged with a licensing consultant. He should have been more proactive, but he wasn't. He expected the licensing consultant to sort it for him. He didn't. He didn't get the service he paid for. But now he is in control. The business is compliant. Those concerns have been allayed. And so we would urge this panel not to revoke the licence, not to suspend the licence, but if there is to be a suspension, to keep it to a period of days or weeks rather than the 3 months that have been suggested. The business is now compliant. It does not present a risk to the people of the district. That is all I have to say on Mr. Desai's behalf, but no doubt there will be questions for him, both from the panel, from licensing and from trading standards. He is here, he will answer.
Thank you very much. I imagine there's some questions. Who would like to go first?
Yeah, I've got a question. So you're talking a lot about the licensing consultant. I mean, I'm concerned, Mr. Desai, that you have not responded or been responding over the course of the year almost to letters to questions posed. And I'm hearing about a licensing consultant that your representative says that you relied on. When did that relationship end with that licensing consultant?
When I was start the show, I used that person for applying the license in 2021. So that's why it's happened this thing. So I again give them to the job. I have this type of problem. And then after I give them money, but he I don't know what he doing, but he is very slow and I am totally reliable on him. And he didn't give them because he asking more money afterwards, because once license review in November, say my job is finished.
So in 2021, you finished?
No, 2021, I applied the license.
Yes.
From this person, Mr.
Yes,
Singh.
he helped you.
Yeah, he helped me to the getting the license. Then after these 3 years, 4 years after I get the problem, so I again use same person.
Yes.
But this time I don't know, he just tried to getting more money.
So when did you end your relationship with him?
It is in after the December when they visited, and I tell them because I was in India, and I called them. I say, but he didn't pick up the phone, and his time gone. So he said, I need more money because license is already ready. Now, if you want to do any further action, you have to pay me more. Simple.
And in terms of responding to the questions raised by the trading standards, did you not feel that you could respond to them?
No, like I can respond, but like I'm depending totally on him. He say I will handle it, I will do it. So that's why I didn't, because I don't know like legal language or anything. If I made any mistake, I'm just scared about like that. So that's why I didn't respond.
Did you have a question?
Yes, a couple of questions, if that's okay. With regard to the alleged underage sales, you quite rightly were pointing out that it's difficult to determine a young person's age just from looking at them. But the Challenge 25 policy would mean that if you subjectively thought someone looked under 25, they would be challenged to provide some form of legitimate identification. Would you agree?
Yes, but I think the point is that her mother bought the vape on the account that was given, and her mother was not said to be obviously under the age of 25. So in terms of the sale that was made, that seems to have been compliant. The question is whether the vape was then supplied to someone who was underage, which on the basis of the evidence that you've received, and I make no criticism, you can only go on the basis of what people tell you, but that doesn't appear to me to be made out. You've got the opinion of someone who saw something a while ago, can't tell you when, and can't tell you much about it, let alone what the person really looked like, whether they knew them or how old they were.
Yes. Forgive me that the complainant alleges two sales. One was the one you described, but one was a direct sale. So the point I was trying to make is it's difficult to assess age. That's why Challenge 25 was brought in. So if that person subjectively looked under 25, the member of staff would challenge them, wouldn't they?
Yeah, of course they would. That's the whole point of the system. And just to be clear, I'm only making that point in relation to the thing that is supposed to be directly witnessed, the mother and the daughter.
Yes.
In relation to the son, Mr. Design's position is that that simply didn't happen.
Yes.
But of course, that's the reason it's in there, is to make sure that underage people don't buy alcohol and
Yeah.
cigarettes. And there's no suggestion that there's ever been any sales of underage alcohol, certainly that be put before this panel.
So forgive me, I think there is like cross purposes. So the complaint says that they did twice witness what they believe was supplies to underage children, and then their own son. That what I'm saying is that one of the sales was directly to someone they suspected was a child, and if a Challenge 25 policy had been in place, the staff would have challenged someone who subjectively looked under 25. Do you agree with that?
I do, but I just say in detail, and they just said twice witnessed what they believe was supplies to underage children. There's absolutely no detail about the other allegation. So again, be cautious about that.
Yes, I understand. And then, Mr. Desires, I wonder if we could just ask you a bit about your investigation with regard to the cigarettes that were seized. What did you determine? So you went away from our meeting. It was left that, well, if you can identify this person, I will speak to them to verify the account. So what did you do in terms of speaking to your member of staff and that sort of thing?
Yes, the reason is the staff, like regular customer builder, some builder from European. So he actually get it from him without my information, because I don't know. And he put it under the counter because he's smoking. And I didn't realize, because I cannot check every day all the counter boxes. He put it underneath, and I didn't realize. And suddenly the trading standard came and they found it. There's only 1 or 2 packet, I think, missing. He smoked, and they took it. And we also explained to the HMRC as well regarding this method. I tried to find out that person. I asked him, my staff as well, who is, say, last 1-2 weeks, I didn't see him. So that is the things, because, and we pay them as well, the fine as well, because HMRC say you have to pay, so I paid them.
Can I ask Mr. Desai, you had the opportunity to not accept HMRC's penalty and refer it to an independent tribunal to argue the facts that you're arguing now.
No,
Why didn't you do that?
Sorry, I already sent them the email, explain everything, but he said fine, and it is my mistake, so I have to pay. Simple as that, because it's my fault. End of the day, it is my soap. Staff made mistake. What we can do?
And just a final point, so the Marlborough Gold was one of the brands that was seized. Could you just tell us how much do you sell a packet of legitimate Marlborough Gold in the business?
Marlborough Gold in the UK one?
Yes, the legitimate ones.
Around £13.50, something.
Okay, so the 10-unit packs that were given as a gift, they would have a
No, might be he paid. No, I say he paid already, not as a gift, but he paid. But he paid directly to the builder from his own pocket.
Okay.
Yeah, I told you on that time, because he brought it from him, especially when he is in Europe or somewhere, wherever he is. But he paid them.
Okay. Can I just clarify that point, because in the meeting, and I sent the email the notes, and Mr. Desai said it was a gift to someone, to the member of staff, but what you're now saying is the member of staff bought illegal products from someone who is therefore an illegal tobacco seller, which is criminal activity on a licensed premises.
I understand, but he even didn't explain me properly. When we are in a meeting, I already told you on that time, which is staff brought it, staff give them someone, even I don't know as well. So my question is, what happened in that things, I don't know.
How often are you in the shop, Mr. Desai?
Once or twice a week.
And so you have this member of staff you're referring
Yeah,
to.
he's earning, so,
Is he there every day?
yeah.
And I think the contraband, as far as I understand it, you're talking about the tobacco now, aren't you?
But what about the vapes, the illegal vapes? Where did they come from?
It is like, like, on that time, that type of rumors in all over the like county area. Everybody selling big webs because small web is expensive. And meantime, after like 1 month or 15 days, it is legal by government, like 5,000, 6,000 pop. So that's why they are supplying that one when people, like they running. And you say it's legal now, you can buy it. So staff brought it.
So you say staff bought it?
Yeah, they brought it. He called me. I say, okay, it is if it is legal, or if it is coming soon, it will be legal. And people are demanding, I need this one, big one, big web. So that's why I keep it.
So if it's coming soon to be legal,
Yeah.
you purchased it when it was still illegal?
Yeah.
And your staff member knew who they were purchasing it from.
Yeah, there is a one wine guy supply. I think I give them number as well on that time. Who is the supply in the form? I written the phone number because it is cash purchase, I know. So I have only his number.
Was that supplied to you?
So
I think I give you
I have no
one,
recollection of that, Mr. Desai. I'm not saying you didn't, but I don't put that in the notes, so.
Yeah, it is in a 99%. It is on when I submit the form, that time I give it to you for destroy purposes. That time I give it to you.
Do you have anything you want to say?
Yeah, I didn't include that in the summary of the meeting. I'm not saying that didn't happen, but I have no recollection of that happening. So yeah, it's difficult to comment on that. But I would like Mr. Desai, if you could just explain. You've explained how they come to be purchased. Why was it that the illegal vapes were hidden under the counter whilst the legal vapes were on display?
As I say, it is my mistake because that time it is not legal. So obviously it is under the counter. That is my mistake, my fault. I apologize for that. And I feel guilty as well. Afterwards is everything nowadays is legal. After might be 1 month, less than 1 month, it will be legal.
So do you understand that the products that we seized were illegal at the time, they're illegal now, and they will continue to be illegal? They've never been legal, they won't be legal. Do you understand that?
But nowadays, like 6,000 pop, 7,000 pop is all legal.
They're not single-use vapes, so they are vapes that have got a replaceable cartridge.
It is from 1st June, from 2025. But nowadays, whatever we brought it at the moment, which is already legal, which is you took it as well, close my 6K and everything, which is at the moment legal.
I think we can give Mr. Desai some advice about the law in addition to what the advice side officer has already given, rather than
Yes,
Jack
thank you.
how I got this. But clearly, Mr. Desai does need to review the law because he's mistaken, unfortunately, and I would be concerned that he might accidentally break the law again in the future unless we correct him.
That's noted. Can I just ask, are the refusal receipts related to age checks? Do they go together? I don't know who anyone who wants to answer that question.
Some are.
Okay.
For instance, the one that I have on the top here, which is from the 15th of April at 13:53, says refused, boy look, 16 to 17, no ID.
Okay. So now, can I ask trading standards and the licensing officer, are you satisfied that the age checks are in place correctly and being used correctly?
I think we would like to have a look at these receipts. We're happy to allow them to be included in the submission.
And then the other huge elephant in the room is the allegation one of the underage sales took place and Mr. Desai saying he didn't sell, he does not have those on the premises, and I'm not sure how we resolve that one. Yeah.
No, I mean, I can only say that From time to time, you might, traders probably do receive vexatious or malicious complaints, but they would usually be anonymous. So this is someone who is a professional person and has gave their contact details, has asked to be contacted. I've spoken to them at length, so I can have a judgment then from my experience as to whether I'm dealing with someone who's got a particular gripe or is genuine. And I concluded that this was a parent who was very concerned, and that they didn't want their details to be publicised, I guess, because they're worried what might happen. But I take the point as well. We don't know because none of us was there. It wasn't a formal test purchase. This is a complaint. But we also got a complaint on the 21st of May, which resulted in Officer Mitchell visiting and seizing an illegal bag. So complaints can actually also be accurate, even though you have got a witness statement or we don't know whether it's true or not. It's up to you as a panel to determine how much weight you attach to that level of complaint that hasn't been independently verified by trading standards.
I'm guessing that you did check, sorry, that there's no possibility that the son was mistaken about where he said he purchased from. Did you clarify that? Yeah.
Yes, I had a lengthy conversation and I explained the complainant had no idea there was a license review pending. I thought that might have been the reason for the complaint. They had no idea. I explained that there was one and that I intended for this information to be applied to be submitted and that it needed to be accurate and the memory needed to be clear. That was all very clearly. And I wrote that down and I emailed it to the person to say, is this an accurate record of what you told me? And I got an email back saying yes. And that's as much as I can do, having not been there at the time.
I'd just like to take it back to asking questions to Mr. Desai, the licence holder. So the other issue is imported food products with unauthorised additives. Where do you get those from?
Yeah, it is the company called DMARC, which is we buy it from them and they directly supply from him, the company. So I have all the invoices, which is because they are the big wholesaler. And almost we also asked them once they catch up with the stickers and things, they told us, they say we are compliance everything 100%. So that's why we brought it all the stuff from them.
So they told you that their food was compliant,
Yes.
yet panel has heard that there are unauthorised additives.
Panel say because we don't know we have to put sticker or not because we buy it from wholesale.
But
So,
even if the sticker says you've got the unauthorised additive in it, it's still presumably illegal.
Correct.
yeah,
So it's still an illegal product to sell in this country.
Obviously we cannot sorry about that, but we cannot like read each and every contents or like when we sell it on the show because we are believe on the wholesale. So wholesalers supply us.
So how do you establish that the wholesalers that sell to you are selling you legal products?
No, we buy it from Booker first. Then Booker was the reference, which is liable company since so many years. So because my whole shop Booker's made it, it is premier. So they give us the detail of this supply. You can buy now American Sweet from there. You can buy these things from there, like that.
And so a different question, but still on food, is the importance of labelling. For example, allergens. Do you understand why it's important to have the ingredients labelled in a way that people here in this country understand them?
Yeah, it is because of we have to know about it, but I don't know that much about the content things.
Yeah.
Which type of contents they use or any English names or anything like that.
But do you understand the importance
Yeah,
of-
important I understand because because we are selling, so we have to look after the public health as well.
Yes,
Yeah,
thank you. It's the public health that I
yeah,
was
termination, yeah.
wanting to understand,
Yeah.
because I would hate, say, a child to buy something or an adult who's
Yeah.
allergic to something. So the invoices show that products have been purchased which contain unauthorized additives.
Yes, what they show that, but what they show is that they've been purchased from a reputable wholesaler. It's not like they've come from an unreputable dealer or a source that can't be traced by trading standards. If that was the concern, that the shop was selling foods from all sorts of places and the ingredients couldn't be traced.
Now that's an interesting point, because I seem to remember earlier in this panel hearing that that traceability was an issue. So I don't know if I need to go back across to trading standards,
So
because I'm hearing that it's traceable.
So there was an issue with traceability because I requested that information and it was delayed to be received. And that was our issue. That I requested for that information to get to me by the 14th of February, and we then didn't receive it until the 25th of March. And ultimately we need to get that, because I gave that deadline, we need to get that information quickly so that we can then refer those products that are non-compliant to the local standards of where DMARC is based. And I have since done that. If I'm able to go into a shop and they can supply me those invoices there and then, that makes the process a lot easier.
So my question then back to Mr. Desai is, why did it take so long to produce the invoices or to, sorry, I've got no.
Mr. Ackworth, but Mr. Desire, I think is best placed to answer matters on evidence.
Yes, it is my mistake because when she came, at that time she told us about the invoice, but it is little bit come out of my mind and I didn't supply on a time. But I'm pretty sure I have invoice. So staff told me just they have to supply the invoice, but it is my out of my mind and I just delayed to supply the invoice. That is my fault.
Can I just say something? So I did email you as well as verbally ask for those invoices. It wasn't just in the shop. Do you agree that I emailed you with that deadline to ask for it and I got no response?
Yeah, I understand, but it is little come out of my mind and that's why.
And can I just further add, the reason I, as a food officer, like to see the owner in the shop, which I've never met Mr. Desai before. I've always dealt with his two shopkeepers who have always been pleasant to me. The reason I like to be able to see the owner in the shop is I am able to easily explain the issues, because they're complicated, to someone in person, rather than them receive a lengthy email from me. And I do also always follow up with an email, but I have told his shopkeepers that I do not trust DMARC as a supplier and that he should look elsewhere for his food. And I like to tell the owners of the shop that, because ultimately they're making the decisions about what stuff is in their shop. I've not been able to tell Mr. Desai that because I've never met him before.
So did you ask to meet him when you visited the store?
No, I've always dealt with the manager that's there, and the most recent inspection I did on Thursday, the manager is able to get hold of Mr. Desai by phone immediately, so that helps.
Yes.
But obviously in person it would be preferable.
And I'm hearing quite a lot that you're not replying to emails. Do you read your own emails and respond to your own emails?
Yeah. But like I say, okay, daytime we are busy, so I say, okay, I give reply on the night, but then out of mind, I'm just deleting it.
The Desai,
Do you have more than one shop? Or
Yeah.
You do?
Yeah.
Okay, so you're busy with other
Yeah,
shops?
that's all.
Yeah. Because on this application, it lists you as the main person responsible.
Yeah.
Okay, I've got another question
Yeah.
on the fire, actually, the fire equipment. So, have you had a fire equipment check?
Yeah, it is company, it is whole estate, so they manage it, and they, because it is in a part of the service
Oh, sorry, of the
of the
building.
whole building. So they rectify in time to time, they put the note, and when it is checked, but I didn't done my personal fire, which is, I don't know. So we already booked, we talk already fire officer, they give us date in a May. So they visit and they give me a personal fire assessment. So I already booked with the fire officer because the officer told me you have to take your own fire risk assessment as well.
And when did you first know that you had to take your own fire risk assessment?
Just I think February or sometimes February or
No, that's not correct. But I've got loads of questions when,
Yeah, I've finished now, yeah.
if I'm permitted, thank you. So Mr. Dessler, we've heard a lot of explanations from you in the last 15 minutes or so, where you put some blame on your former licensing consultant, Mr. Singh. You blame your staff, you blame the wholesaler. Can I just ask you really directly, who is responsible for compliance at your premises?
me.
Thank you. Who is responsible for ordering stock at your premises?
It is me, but I didn't order. It is staff order.
But you are responsible for
Yeah,
what
I am
appears in your shop.
Yeah,
Okay. Who is responsible for complying with the Licensing Act 2003?
me.
Who's responsible for complying with the food safety regulation? Who's responsible for complying with all the trading standards regulations?
Me.
Who's responsible for complying with fire safety regulation?
Me.
Thank you. So we just had an exchange about your use of email. Why have you never contacted the licensing authority directly in relation to any of the issues that have been raised at your premises since the first licensing inspection on the 3rd of July?
Yeah, as I told you, because I already give them work to the Mr. Singh, and I already contact with the Mr. Singh, and he said, okay, I will look it into it. I will handle it. I give them reply, but he didn't give them reply on a time. So that's why I stopped that using that person. Afterwards, in November, once we get the license review,
When did you first realise that Mr. Singh wasn't responding to us?
because when I was in India, and he didn't give them reply, and then he said, I need more money. And
Yeah,
then
with all due respect, I'm not really interested in your financial arrangements with Mr. Singh. What I'm trying to get at is, at any point after the first inspection on the 3rd of July, right up until today, you could have stepped in at any point if you weren't confident that Mr. Singh was doing the job you paid him to. You could have stepped in at any point and said, oh, I'm concerned that these conditions aren't being complied with.
no, it is on a 24th. We are waiting for you on a 24th because you supposed to come on a 24th of February. And that time is 100% is done. And you didn't turn up. And
Who didn't turn up?
Sorry, can I?
Yes,
Please,
I think, yeah, I think we.
question is supposed to be allowed, but cross-examination
Yeah,
is not.
Yeah, no, I think
And
it's
the
not,
code
it's
is
not
not
place for that.
It's rather aggressive for a panel hearing.
Yeah.
I just wonder if we could.
Yeah, I think we will call it to a halt, sorry. French.
I don't think it's a case of being called to a halt. I think it's maybe the way that I don't think we should be stopping Mr. French trying to tease out whatever he's trying to tease out. But I think it maybe if you can address through the chair the questions you want to actually put
Sure.
to us to decide.
So you just said something there about February 2025. Who was supposed to turn up on February 2020?
the licensing officer for the visit.
Well, that would have been me, and I had no recollection of what you're referring
And
to.
20, then after, because 24th whole day I was in a shop. And I think staff told me when you visit on December, I think, or February, January. That time he told me 24th of February, the officer will turn it up again because it's not compliant still, because there is a one sticker missing, which is please leave quietly.
Yeah, I
So-
think what we're establishing here is that possibly Mr. Desai wasn't taking responsibility as he should have.
I think Mr. Desai, I don't think you can actually at this stage draw those conclusions. I think you need to listen to what Mr. Desai and Mr. French have to say, and
Okay,
then
fine.
we'll consider that.
I just, Mr. Desai, could you be mixing, because I've got some dates written down here from what I heard from Trading Standards, so could you be mixing the dates of the visits from Trading Standards with the licensing officer?
No, I don't have at the moment with me all the dates.
Okay, thank you.
Just to clarify, there was no licensing visit scheduled for the 24th of February, so I'm not entirely sure what you mean. On paragraph 16 of page 61 of the submissions of this panel, which I appreciate your current legal advisor didn't write, it says that you accept that the license condition breaches as set out were accepted and are accepted. Do you still accept they were all factually license breaches at the time of the inspection?
Yeah.
Yeah?
Yeah.
Okay, well, thank you. You've heard a lot today about the licensing objectives. Yeah. Can you explain to me in your own words what you think the licensing objectives are?
And proxy shell, challenge 25.
Okay, which licensing objective is that?
He's not a lawyer. And so I think to be fair, because this is coming very close to what would be considered cross-examination.
It's not.
As someone who cross-examines people for a living, it is. And is being done in a tone that has not been similar to the way that other people have been asked questions. And so if Mr. French wants to ask, how do you promote X licensing objective? I can't see that objection to
I
that. but-
don't think that's what he is asking, is it? I think he's asking, the problem is, I think what Mr. French appears to be asking is, and teasing out, is Mr. Desai's actual understanding of what those licensing objectives are, as he is the DPS and license holder. Would that be correct?
That is correct.
So maybe Mr. Desai could provide an answer to that. I think the question being asked, Mr. Desai, is what is your understanding of the four
Like
licensing
public safety,
objectives?
for the harm for we have to look after for the children as well, harm for the society, public nuisance, like that type of thing. You have to look it into all the objective.
Okay, and how do you promote protection of children from harm? How do you do that in your shop?
We normally, I'm 110% sure till date, I never sell because for like personal opinion and personal religious reason, we don't serve any children. It is my policy. I never ever sell any children, any soaps. All of my 3 soaps, I never ever sell children. Straight away I reject. And till date, I don't have any problem last 10 years. This is the first time happened, which is with the e-cigarette. Normally, I never ever get any police record or anything for the selling underage, nothing.
So what I'm hearing, Mr. Desai, is that you personally would never sell.
Not personal, even staff is strictly warning, no staff can able to sell. If no business, that's fine, but don't sell to the children. Simple as that.
You mentioned Mr. Singh as being the licensing advisor that helped you draw up the conditions and then who you approached when you had these visits last year. Have you got anyone else to advise you since you no longer use?
No, then after I contact to the personal solicitor and then,
Thank you.
Mr. Singh, when you say you're confident that you never made any underage sales to anyone, how would you know that? Have you received feedback letters from this author, from Trading Standards or the police to say that you have passed test purchases?
yeah, on this shop, I don't have any letter, but my other shop, I have a 3-4 letters when they send to the someone and it look like over 18 or challenge 25. So we ask them for the ID and I refuse him. So then I get the letter from Trading Standard. You are the pass through this process.
But specifically talking about this store in Didcot.
This store, I didn't get any letter till date.
Right. So I can say that I know for certain that Trading Standards have never purchased at your store. Whether the police have, I do not know. So given that there's been no testing, how can you be so confident that no underage sales are being made from your store?
Normally, I ask them ID all the time, most of the time. Even staff also ask for the IDs. That's why this much refusal papers. Otherwise, you cannot even found it any shops. Even I seen lots of shop friends as well. Nobody have like that much refusal letters in a book and anything like that. So because every day around, 2-3 people I refuse, like children or girls or whoever come. So that's why my record is also very high for refusal.
Thank you.
I don't know whether you've reached the end of questions.
I just have one more question, if I'm permitted. So you're one of the joint directors of Saksha Limited, along with Mr. Patel, is that correct?
Yeah.
And I think you said to Councillor Simpson earlier that you were in the shop perhaps 2 times a week. How often is Mr. Patel?
One time a week.
1 time a week.
Yeah.
Okay.
That actually links with another final probably question that I have, which is when you're away, you mentioned a couple of times that you've gone to India. Who then is responsible? Is it?
Yeah, the manager, Mr. Nimesh.
Mr.
Nimesh.
And this, I don't know how licensing works, but presumably needs to.
Yeah, he is the. I authorize him for the selling alcohol and cigarettes, and he got the as well the proper examination and everything. He get the certificate level 2.
And okay, I'm not quite sure how the authorization works. That probably is a question for the other side, actually.
Yeah, so each license has a designated premises supervisor who generally holds a personal license. It's generally the DPS who would authorize people in their absence to sell alcohol, and that's usually done through a written authorization list after they've done the relevant
So Mr.
stuff.
Design has complied with that from what I can understand.
Yeah.
So I think Mr. Is it Nimish is his
Luma.
first, yeah, so he's the person in your pack at page 107 has a personal
Yeah,
license as
Thank
well.
you.
There's no requirement for the DPS to be on site all times, but they must authorize others to sell alcohol
Great. Thank you
in their
very
absence.
much. Does that conclude questions?
From me,
Thank you. That concludes the presentation stage now, unless anyone else gives an indication otherwise. And we will now move on to the final submission stage and ask if they wish to summarise their view before we go into the closed session to make a decision. Where will we start?
It's starting with me. You've just heard. I'm not going to trouble you by repeating what I just said. You've heard the evidence. It's a matter for you. We would urge either an election or a suspension of days. That's all I have to say.
Yes, thank you, Chair. I'll just reiterate a point I made right at the start of my submission, which is it might have felt like it's Mr. Desai, he's not on trial. This isn't a matter of guilt or innocence. What we're trying to determine is whether the licensing objectives have been breached, and if they have, what should we do to try and seek future compliance? But I think the issue that we've had here is some mistakes have clearly been made, some misunderstandings of legal issues, but that's been exacerbated really by the poor communication and then further issues being compounded with further issues. And again, not wanting to repeat myself, but I'm sure be acutely aware of the reduction of resources to local authority. So Oxfordshire Trades and Standards has literally 50% less officers than it had in 2010. But the demands on us with new inventions like vapes and the explosion of illegal tobacco means that there is more demand our time than ever before. And you can see through the timeline that the sheer demand that one premises is caused to numerous officers, and it's not sustainable, which is why it's really with reluctance really that we've joined this review. As I hope you can see, we did try and resolve this issue by advice. We could have reviewed straight away. What we were hoping, and it's to be acknowledged, there hasn't been a repeat of illegal tobacco or the illegal electronic cigarette situation. What we were hoping to see is that these meetings are a kick up the backside, that conditions do get complied with and other regulatory issues are given a priority. And unfortunately, that hasn't been what we have seen. And so we will work with Mr. Desai again at the end of this hearing, because clearly there's a misunderstanding about the law around vapes, which might mean that further non-compliance occurs not through deliberate criminal acts, but through mistakenness. The illegal tobacco is, as you've heard, it is regarded by the statutory guidance as being particularly serious. And Mr. Desai has admitted today that the products weren't a gift, they were purchased by a member of staff. And that is exacerbating the reasons that we brought the review in the first place. So, yeah, in conclusion, we supported the licensing authority bringing this review, and I hope we explain the reasons why to you today. Thank you.
Just very briefly. So the granting of a premises license is a privilege, but with that privilege comes responsibility. Responsibility to promote the 4 licensing objectives. Responsibility to comply with regulatory requirements, be that under the Licensing Act, Trading Standards legislation, or food safety legislation, or indeed fire safety. In this instance, a premises license holder, who is also the designated premises supervisor, a person with significant control over the company, has been found wanting in all of those areas. Serious offences have taken place at premises. This includes the sale and or storage of smuggled tobacco on the premises, the sale of illegal high capacity vapes, and multiple and persistent breaches of license conditions, and the discovery of food products being sold past their use-by date, mislabelled or contained banned additives. So this spans a multitude of regulatory and legal bits of legislation frameworks. The sale or storage of smuggled tobacco alone would be enough for the licence to be considered to be revoked, according to the Secretary of State's guidance. The licensing authority and colleagues in trading standards have attempted to work with the business, as is recommended in paragraph 11.10 of the Secretary of State's guidance, and we've set that out today. However, the premises licence holder has not heeded such warnings, and indeed has not even felt the need to make contact about the issues he was made aware of all the way back in July of 2024. As mentioned earlier, this non-compliance is ongoing as we sit here today. We're still not satisfied that all of the licence conditions, the reasons detailed earlier, are being complied with. Paragraph 11.18 of the guidance states that the licensing authority should not therefore repeat the same process when considering what action to take, and should take into account the failure of licence holders to engage despite repeated warnings by responsible authorities. Premises licence holder has had numerous chances to, quote, step in, unquote, or contact the licensing authority or training standard service about these issues, and has failed to do so. Local shops serve local communities and our friends, our constituents, etc. The licensing authority and public at large need to have confidence that the owners of said shops are not putting them or their loved ones at risk. A premises and license holder that doesn't comply or is unable to comply with multiple sets of legislative and regulatory requirements should not have the benefit of a premises license to put the public at risk in the ways that's outlined here today. As paragraph 11.26 of the guidance states, the licensing authority's duty is to take steps with a view to the promotion of the licensing objectives in the interests of the wider community and not those of individual license holders. It is respectfully submitted, therefore, that as per the submission on page 29 of your papers, that the premises license for Premier Store 150 Broadway, Didcot, be revoked in the interest of promoting the full licensing objectives and safeguarding members of the public. Thank you very much.
Thank you.
I think my final comments would just be to remind you what I said at the start, which is you must take steps that you feel were appropriate to promote the objectives in question.
Is it now? Kindly ask you.
Okay, if I could just, if everyone's quiet a minute, and we'll just wait for Susie to switch off the stream, or put it on pause before, and then we'll return later.
Thank you everyone for returning, and apologies, you know, we had a lot to discuss. So I can confirm that this decision has been reached. The panel took into account the written and verbal evidence submitted by all parties, the relevant provisions of the Act, the Secretary of State's guidance issued under Section 182 of the Act guidance, and the Council's licensing policy. The panel only considered evidence relevant to the licensing regime and to the promotion of the licensing objectives. The panel did not take account of non-regulated activities, any activities not within control of the premises, or those which were not relevant to the licensing objectives. The panel considered that there was a continued risk of undermining the licensing objectives of prevention of crime and disorder and the protection of children from harm, and that revocation was the only appropriate and proportionate response to the issues giving rise to the need for the review. Please be aware that a decision notice with full reasons will be sent out to attendees within 5 days. Any party may appeal against the panel's decision. Any appeal must be made to the Magistrates' Court within a period of 21 days beginning on the day on which the appellant is notified of this decision notice. This has to be made in the correct manner, accompanied by the required fee. Before I formally close the meeting, are there any outstanding questions for myself or officers?
No, thank you. No, thank you.
Thank you.
Thank you.
This meeting is now closed at 4:25, and I thank everyone for their attendance today.
Thank you very much.
Thank you.
Thank you.
You're supposed to stream Susie.